Good morning, everybody, and welcome back to Coffee with Craig, our weekend edition. Very much appreciate you guys taking the time to join us. Please make sure to like and share these videos and encourage your friends, your family, your enemies to go ahead and like and share our Facebook page. Also to subscribe to our YouTube channel so that you can get all of the information so that we can have a fully informed discussion about the Second Amendment in politics, culture, business, you name it. So let's get into today's topic. As you guys know, there was a recent court decision in which, the Supreme Court decided yet again not to take up another Second Amendment case. And without getting into the specific details of this particular case, this was Sylvester v. Becerra, which deals with the 10-day wait period in the state of California. I wanted to get into something that, in particular, that was brought up in the dissenting opinion, the lone dissenter in this particular case. Now, mind you, I need you to understand something. Contrary to what people are telling you, the Supreme Court deciding not to take up a case does not mean that they necessarily agree with the outcome or the decision. It just means that less than 1% of all cases that are submitted to them actually get taken up. So this was just one that they chose not to take up. And it caused a question to be raised by Justice Thomas, which I thought is a quite valid question. And that is the Second Amendment a second-class right? Is the right to keep and bear arms a second-class right? One of the things that you learn as you sit through a lot of these cases is you learn, first and foremost, there's this whole kind of process that is set up in terms of how they determine what level of scrutiny they're going to give particular rights, right? There's strict scrutiny, meaning it is what it is, and you better have a darn good reason for violating this particular right. Then there's intermediate scrutiny where, okay, yeah, it's an important right, and but there needs to be some sort of, it's got to pass the smell test. And then there's what's called rational basis, meaning if you can come up with a reason why, any reason why you can violate this particular right, well, then that's good enough for us. What's interesting is that when you talk about things like due process, or you talk about rights like the right to free speech, those are always given strict scrutiny, or at the very least, intermediate scrutiny. When it comes to the Second Amendment, once again, the second of our enumerated rights in the Bill of Rights, it's almost always rational basis, meaning they almost always allow a local municipality or a local government to come up with whatever reason they want to infringe on the right to keep and bear arms. Oftentimes, the closest you get, the best you get when it comes to the Second Amendment is intermediate scrutiny, where at least, you can't just pull anything out of your rear end. But for some reason, and I don't understand why, I don't understand how is it that something, and then once again, no matter where you are on the issue of abortion, right? I don't understand how something that is clearly not a right that is enumerated in the Constitution is worthy of all of the decisions that have been made, all of the court cases that have been heard on it. But for some reason, the Second Amendment, the right to keep and bear arms, which is specifically enumerated in the Constitution, keeps getting ignored. You'll find that a lot of folks on the anti-gun side will tell you that, it wasn't until Heller when the right to keep and bear arms was really fully established as an individual right. And you know what? Legally, from a technical aspect, they're right. But then again, I guess that's because most of us understand that shall not infringe seems pretty basic. It seems pretty obvious. One should not have to go jump through a bunch of different hoops in order to determine what shall not be infringed. The right to keep and bear arms shall not be infringed. I don't understand what is not so obvious about that. So, in 2008, we had a decision, and then in 2010. And since then, the Supreme Court, has refused to take up any Second Amendment cases. And that was one of the things that Justice Thomas, once again, the lone dissenting justice, decided to point out and talk about in his dissent. He talked about how the Supreme Court, once again, is treating the Second Amendment as a disfavored right, that there is absolutely no reason. He notes and he points to a number of the things that were done, in particular in this case, in particular in the case of Sylvester, where they just flat out ignored all process, the way in which decisions are usually made. The Ninth Circuit I'm referring to, the Ninth Circuit Court of Appeals, just flat out ignored how they're supposed to do their job. And they just made stuff up and said, yeah, no, we're sorry. We don't believe in the right to keep and bear arms, and therefore, you have a 10-day waiting period. They literally ignored it, and he noted in his dissent, he noted that they went back and they ignored. See, keep in mind, at the trial court level, gun owners won. There was enough evidence that was produced that said there is absolutely no reason, no foundation for a 10-day waiting period for someone who already owned a firearm, especially if that individual already had a concealed carry permit. That went to the Ninth Circuit, and they ignored every single factual finding by the district court. Ignored every single one. And then when it went to the Supreme Court said, well, yeah, no. Well, the worst part about it is it's not so much. I don't know whether or not they care whether or not the Ninth Circuit just decided to make stuff up because they do it all the time. If nothing else, and this is one of the things that Justice Thomas noted, he said, look, if nothing else, we can't have lower courts going and flat out ignoring the decisions that we make here. And that's exactly what's happened. Local municipalities in passing laws, local courts or district courts, even district federal courts have decided that, you know what? Yeah, I know there's an individual right to keep and bear arms, but you know what? We're going to do what we want to do. We're going to make up our own law. Despite the fact that, like right now, once again, another very, very, very important case as to whether or not there is a right to bear arms. Right now, there are parts of the country where you have a fundamental right to bear arms. As the decision that was made in the Wren case, well, because they're not going to, Washington, D.C., they decided they're not going to appeal it to the Supreme Court. So that entire district, that entire circuit, yeah, there is a right in that district to be able to bear arms. But here in the Ninth Circuit, we don't have a right to bear arms because they shot down Peruta, which is the case out of the Ninth Circuit. They shot it down. They refused to hear it. So I guess we're all not treated equal, huh? I guess there really is no equal protection because some people have a right to bear arms and some people don't. Why? Well, guns. And the Supreme Court has just flat out acknowledged once again that they're going to treat the Second Amendment, our right to keep and bear arms, as a second-class right. And it is sad. And the only thing I can say is that I am very happy that Justice Thomas is there. I know that there is now a witch hunt after Justice Thomas and people talking about trying to impeach him and all of that. But you know what? He is the last individual who is willing to stand for all of our liberties, all of our rights, all of our freedoms. He is the one individual who's willing to say that, no, the Second Amendment is not a second-class right and deserves the same protections as every other fundamental right that is enumerated in our Constitution. What he has recognized is that lower courts and politicians, whether it's through executive fiat of the White House or governors or attorneys general, or whether it's in courts who've decided that they now want to legislate from the bench, that they want to write law from the bench. They have decided that our way of doing things, that our way of life really doesn't mean a whole lot. And see, here's the thing that I want you guys to understand. And you know, for those of you out there who don't believe in the Second Amendment, who don't believe in the fundamental right to keep and bear arms, you know, if people can flout the law and flout the Constitution on something with which you disagree, then there is absolutely nothing keeping them from flouting the Constitution on something with which you agree. So just know that if you are not willing to stand up to tyrants who seek to inflict their will, whether it be through judicial fiat or executive fiat or judicial activism, unless you are willing to stand up to them on something that you disagree with, then know that none of your fundamental rights are safe. None of them. All of them are in jeopardy. And it's important that we stand up to tyrants no matter where they are, whether they're in the White House, whether they're in the governor's office, the attorney general's office, the legislatures, or whether or not they're sitting on the Supreme Court. Anyway, that's how I see it. Folks, thank you so much for tuning in today. We really appreciate you. Appreciate you being a part of the fight for civil rights. Remember, we got to use them or we're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.